Hello and welcome to this week's edition of Wednesday Wisdom. I am JB Hilliard and these are our weekly video snippets, little tips and suggestions and just informational videos designed to help you move forward in your estate planning or in any kind of legal situations you might find yourself in. And this is sort of an extension of our monthly newsletter called Sidebarred. And if you want to get that, if you're not already on our email distribution list, you can sign up right there. There's the website. You can go right to the home page and a pop-up box will appear for you to just enter in your name and email address. And we promise not to spam you. But moving forward for this week, I want to talk briefly about holographic wills. You may have heard that term before, and a lot of people correlate holographic with handwritten. And there is a slight difference, at least here in Georgia. So holographic wills are basically handwritten wills, but technically holographic wills are not valid here in Georgia, whereas handwritten wills are. So if holographic is the same as handwritten, how can that be? And you know, Georgia is special. I've been down here over 20 years, so I think I'm validated enough to say that. But the difference is a holographic will, and those are legal in other states, but a holographic will is handwritten without the formalities of a regular will. So where a handwritten will here in Georgia is allowed, is valid, if it has been witnessed by at least two uninterested or objective witnesses. And when I say that, I mean that those witnesses don't have anything that they're going to be receiving as beneficiaries of that will. And if you're doing a self-proving affidavit to attach to the will, then that means you and your witnesses all signed that as well, and that's notarized. That part is notarized. So again, you can handwrite your will if you want to and write everything out and spell it all out. But if it's not witnessed and if you don't sign it, then that's considered holographic, and that is not valid in Georgia. So it would be as if you died without a will. So you want to make sure, if you're not going through the formalities of working with an attorney to get that drafted, or if you're not typing it up all nice and pretty and putting it in a nice binder or something like that, that's okay, but you still must make sure you go through the formalities of the proper execution to make sure it is valid. When the time comes, you're going to want to make sure that has happened. So again, as always, I thank you for watching, and we'll see you next time.